shoot my baby in the face and piss on him and in his face, and he was going to kill both of us. And proceedings stopped at that point. Mr. Peacock made a motion for mistrial. I took the jury out, sent the jury home. We had some discussions yesterday and then further discussions this morning. I'm going to rule as follows. We all know that the charges pending against Mr. McTear include first-degree murder under both theories of premeditation and felony murder, murder with an assault against Miss Bedwell, aggravated child abuse against this small child, Emmanuel Murray, battery against Miss Bedwell, and kidnapping involving this small child. And as we know, the state files notice to seek the death penalty if they were convicted. As we all know, we spent an entire week beginning August 12th to select a jury. We started the testimony just yesterday. And as we all know, the state's primary witness was Miss Bedwell. She was the fourth witness called by the state. Prior to trial, we had considered several pretrial motions, many pretrial motions, which included a defense motion in limine which sought to exclude testimony from Miss Bedwell that McTear had threatened her by telling her these things. I consider written arguments of counsel in which the state conceded to the request for relief in its written responses of May of 2012 and October 2012. Noting in its responses that such would not be relevant because McTear uttered those words in March 2009 in an unrelated case, hence they would not be competent evidence in the instant homicide offense of May 2009. So I thereafter entered an order in limine directing the state to not make mention or attempt to introduce evidence of McTear's statement. As we all know, when asked by the prosecutor during trial to describe the nature of the phone calls, we know what she said. Immediately after that, we had some brief discussions, and defense counsel posited that there is no remedy that he could conjure that could cure the extreme prejudice caused by these comments, and asked for a mistrial. And yesterday, the state acknowledged that it had conceded to not attempt to elicit the complaint of testimony, and that it was aware of the order in limine, but submits that when the question was posed to the witness, it was anticipated that she would respond that his calls were threatening in nature, not that she would repeat the specifics of his verbal threats to her or the child. And the state yesterday additionally acknowledged that the testimony would not be relevant or admissible, given that it related to a different case, and that the state would not have attempted to elicit that evidence. Notwithstanding, the state suggested yesterday and does today that the trial should proceed with or without a limiting instruction to the jury. So today I considered additional arguments by the state and defense counsel, and Mr. McTear personally acknowledged that he recognizes and understands his constitutional right to proceed with the trial with this jury, but he acquiesced in and agreed to his counsel's motion for mistrial. Additionally, after speaking with counsel this morning, I reviewed my order in limine dated August 16 of 2012, wherein I specifically ruled that evidence from case number 09-5749, for which Mr. McTear was acquitted, would not be admissible under any circumstances. And the complaint of testimony here today was evidence in that case. I also reviewed the transcript of the questions posed, which I simply now read into the record. As counsel did, this court last night researched all the cases cited by counsel. Both sides are very opposite to the issue presented here. But the law generally provides that the granting of a motion for mistrial is not based on whether the error is simply prejudicial, but rather the standard requires that a mistrial be granted only where an error is so prejudicial as to vitiate the entire trial. Such a mistrial is necessary to ensure that the defendant receives a fair trial. And coincidentally, parenthetically, I will render a written order to this effect very shortly. And I recognize that the power to declare mistrial and discharge a jury should be exercised with great care and caution, and should be done only in cases where it's absolutely necessary. In order for the inadmissible complaint of testimony to merit a mistrial, the testimony must deprive the defendant of a fair and impartial trial, materially contribute to a conviction, and be so harmful or fundamentally tainted as to require mistrial, or be so inflammatory that it might influence the jury to reach a verdict that it otherwise might not. This testimony in question, that should not have been heard by the jury, in this court's judgment, serves to materially establish or otherwise support critical elements of the charges of premeditated murder of the infant, aggravated child abuse of the infant, and kidnapping of the infant. The jury heard testimony She should not have heard under any circumstances. In this court's judgment, this testimony would vitiate the entire trial. And so in this court's conclusion, mistrial is necessary to ensure that the defendant receives a fair trial. I deem that there is no remedy to cure the prejudice at this point, so I'm going to grant the motion for mistrial. I'll say this, that I do this with extreme reluctance. I don't suggest in any way that any counsel did anything inappropriate. I don't think any lawyer here today wants us to start all over again. I know this judge does not want to start all over again, but that's what we must do. So I'm going to declare a mistrial reluctantly. And I'm going to bring these 16 citizens out and explain to them why we have consumed a week plus of their time. I suppose many of these folks have had to change their work schedule, vacation schedules, or what have you, and are prepared to spend the next 3 weeks with us, the next 2 weeks with us. And it's unfortunate that we had to do this, but it's necessary. Let me just ask, as a matter of just discussion, Mr. Gale, did you have any reason to believe or think or suggest that there was anything inappropriate on Ms. Bedwell's part when she testified yesterday?
I don't believe so, Your Honor, and I think what happened was a consequence of two things. Her simply confusing the threats that were made at different times. Also, as well as the fact that, of course, she was very emotional on the witness stand, and there was the additional factor that I was not even aware of yesterday of these text messages that were being sent to her from Mr. Murray, who was here in the courtroom. So I think it was a combination of those things that led to what happened yesterday.
Well, when we try this case again, and we will, expect we will, those matters will certainly be addressed. And no judge, including this judge, would tolerate a witness on the witness stand being influenced in any way, shape, or form by anyone. And this court certainly has the powers of contempt for that purpose. Are all jurors here?
Yes, sir.
Please bring them up.
Ready, Judge?
Yes, sir.
All rise. Jury hearing.
Okay, our jurors are back in court and seated. Defendant and counsel, please be seated. Jurors, here I want to give you. Yesterday we recessed a bit early, and I told you that something had happened which required the lawyers and the court to get together and discuss several things. And what it involved was a witness on the witness stand yesterday, Ms. Bedwell, testified some things that she should not have testified to. This case, as you can imagine, has been in litigation for many, many years. There have been numerous pretrial motions filed, numerous hearings held, on which this court has rendered several orders. And a couple of those orders had to do with things that the two folks the jury heard yesterday that had been ordered should not be testified to or brought up in any way, shape, or form. As a result of that, when we excused you yesterday, it was because counsel had moved for a mistrial. And rather than rule on that hastily, I had you excused and had you come back this morning at 9:30. Yesterday afternoon, the lawyers and I had engaged in several discussions. We all researched some matters last night, and we all had further discussions this morning starting at 8:30. And I reached a conclusion that as a result of those errors, if you will, that occurred in the trial, that there's no way that we can proceed with a fair and impartial trial to the state end of the defense. So reluctantly, and I say very reluctantly, I'm obliged to and required to appropriately declare a mistrial. I apologize to all of you folks. You spent a long time with us last week going through the jury selection process. It was tedious, it was long, and it was important, it was necessary. And you abided my orders to stay away from reading anything in the media about this case. And there's been a lot. Believe me, there's been a lot. And there was a lot this morning after what happened yesterday. I trust none of you were exposed to that. But I know that some of you may have arranged your vacation schedules, work schedules, what have you, in order to accommodate us, and we appreciate that. These things happen from time to time. I apologize that it did. I apologize to each and every one of you sincerely for consuming so much of your time. But we do appreciate what you've done. My order to you to not read anything about this case is now lifted. You're free to talk to anybody you want about this case. You can read the newspapers, watch television, anything. And trust me, there's a lot on TV right now, a lot in the media right now, and there will be today. But having said those things, with my sincere apologies on behalf of everybody in the court system, I'll discharge you at this time with my thanks and apologies for consuming so much of your time. Thank you. Please drive carefully. We'll see you next time. Thank you.
All rise. We'll bring it to the motion.
Okay, our jury left can all be seated. Counsel, how do you all want to handle the rescheduling of this case? State.
Your Honor, Ms. Doherty and I were just discussing the issue with, of course, 90 days after a mistrial. However, case law says that where speedy trial has previously been waived, that would apply also to that 90-day period. So I don't believe we need to reschedule this within 90 days.
So what's your suggestion? What should we do with the case follow-up?
I don't know if we want to set it for a status conference at this point to see if we can agree on a date. I have my calendar with me now if we want to try and reschedule it. Another thought that occurs to me, and I know the court's dealing with a very similar situation in another matter, is that this is going to, of course, increase the media attention in this case, and it's going to make it more difficult to get a jury panel the next time we try this case, and I think we're going to need substantially more than 200 potential jurors to start out with.
Well, having said that, what are your suggestions with respect to time?
Judge, the only trial I have coming up at this point is another death penalty case. It's probably going to last 3 weeks in early February. So I'm available at the court's disposal with that restriction. And I have a 2-week-long 3.851 hearing that's supposed to occur beginning October 7th.
Mr. Peacock, Ms. James?
this is part driven by what the court's calendar is and when time is available. I know that the one thing that in our discussions that I would suggest to the court is that I know Mr. Covington's pending motions are set starting, I believe, the first Monday in December
yes.
for a period of 2 weeks. And I don't think this could be tried in 2 weeks, but I don't know if we look towards the possibility of using that time when Mr. Covington's matter is set. I understand Mr. Pruder is not here at the moment, so I don't want to be discussing the ultimate outcome from that case, but that was one time period that was suggested, but that would certainly take us up to the Christmas holidays with the need for jury selection and trial.
You mean suggesting maybe trying this week, this case in December?
Yes, but I think that may be too soon. The one thing that I have to find out is when other witnesses are available. That's the first available date that I was going to suggest to the court is available, but we may be looking at, obviously, in 2014.
Let's set a status date in a couple of weeks. You guys get together and see about your witness issues, trial schedules, and get with Jeannie. Jeannie knows our trial schedule. Is a couple of weeks enough time to find that out?
That should be fine, Your Honor.
Yes, Your Honor.
We give 2 weeks status. I can hear you. September 13th, was that Friday? September 13th, a Friday? It is. That's a Saturday.
Friday.
September.
That's fine, Judge.
Okay, we'll be in recess on September 13, 8:30 for status.
Yes, sir.
And we release the evidence to the state.